Relocating with a child in Louisiana involves specific legal requirements, primarily governed by the state's family law statutes. If you're thinking about moving to a new place with your child that changes the geographical distance between the child and the other parent, or if you want to prevent the other parent from doing so, it's important to understand the legal rules that apply. Moving, or relocation, means changing where your child mainly lives for 60 days or more. But if the move is just for a short time, it doesn't count as relocation. Before a parent can move with a child, there are specific legal steps that need to be taken. This video will provide a step-by-step guide to this process. Let's get started. The first step is to speak with the other parent. Communicating with the other parent is a critical step in the process of relocating with a child, and it's encouraged to do so as early as possible. This discussion should ideally happen before any formal legal steps. Before resorting to court intervention, parents may be able to negotiate an agreement regarding the relocation and any necessary modifications to the custody and visitation arrangements. Reaching an agreement outside of court can save time, reduce legal expenses, and minimize stress for both the parents and the child. However, it's advisable to have the agreement in writing and submitted to the court for approval. This formalizes the agreement and makes it enforceable, providing legal protection if disputes arise later. The second step is to provide the other parent with written notice of the intent to move, should both parents find themselves unable to come to an agreement. Before filing a petition to the court, Louisiana law requires the relocating parent to provide the non-relocating parent with written notice of the intent to move. This notice must be sent well in advance, usually 60 days before the planned relocation, and include specific information required by law. This notice usually needs to include details such as the new address, the reason for the relocation, and proposed changes to custody or visitation schedules. Upon receiving the notice, the other parent has a specific period, often 30 days, to respond. If the non-relocating parent agrees with the move and the proposed arrangements, they may not need to take further action, though it's wise to formalize the agreement through the court. If the non-relocating parent disagrees with the relocation, they must file a formal objection with the court within these 30 days. This objection is essentially a legal document stating their reasons for opposing the move. It signals to the court that there is a dispute regarding the relocation that requires judicial intervention. If the other parent does not agree to the relocation, a petition is filed in the court where the current custody order was filed. The petition should outline the reasons for the move, how it would benefit the child, and propose a new custody and visitation schedule that accommodates the move while maintaining the child's relationship with the non-relocating parent. If an objection is filed, the relocating parent cannot move with the child until the court has held a hearing and granted permission for the relocation. The court will schedule a hearing to consider the objection and determine whether the relocation is in the best interest of the child. The next step is to attend the court hearing. During the hearing, each parent will have the opportunity to present their case. This includes providing evidence, calling witnesses, and making legal arguments. The parent wishing to relocate must demonstrate that the move is made in good faith and for legitimate reasons, such as employment, opportunities, family support, or significant life improvements. When relocation is contested, the court will consider several factors to determine whether the move is in the best interest of the child. These factors can include the reason for the move, the impact on the child's relationship with both parents, the child's educational, health, and social needs, and how well the child is likely to adjust to a new community. Finally, the judge will make a decision. After hearing both sides and reviewing the evidence, the judge will make a decision. The decision will be based on what the judge believes is in the best interest of the child, considering all the evidence and arguments presented. The judge may approve the relocation, deny it, or approve it with specific conditions, such as a revised visitation schedule. Both parents are required to comply with the court's decision. If the relocation is approved, the relocating parent can proceed with the move under the terms set by the court. If the relocation is denied, the relocating parent must reconsider their plans. Due to the complexity of relocation cases and the potential for significant impact on parental rights and child custody arrangements, seeking the advice of a legal professional experienced in family law is highly recommended. Thank you for taking the time to watch our video on relocating with a child in Louisiana. If you're looking for more detailed guidance and resources or need further assistance, we invite you to explore our website louisianalawhelp.org. This information is designed to help you navigate the process of getting child custody, along with any other legal matters you may be facing.